We are here with Advocate Matthews in Edinburgh. Sir, the President of the Supreme Court Bar Association has sought reconsideration of the electoral bonds case. What is your opinion of this?
The judgment of the Supreme Court in the electoral bonds case, I believe, has been received well by the most of the stakeholders and the public at large. But in my opinion, the judgment of the Supreme Court is on a wrong premise. I don't intend to comment on the letter which was addressed by the President of the Supreme Court Bar Association, because the concerns we have raised and the reasons for which I don't exactly welcome the judgment are entirely different. The electoral bonds, how good or bad an idea it is, I'm no expert to make any comment on that. My reservation about the judgment is entirely different. It is legal and is based on democratic considerations. See, the electoral bond, well, is it a solution to bring an end to the corruption or the black money involved in electoral funding? That's a question which the Parliament addressed. And there has been a lot of deliberations in the public domain. And a law was passed. The law may be bad, the law may be good. How far the law is good, maybe we could learn from the experience. And again, whether they like the judgment, whether it is a welcome one or not, all depends upon the perception of the people. Say, maybe those who support the BJP or the Prime Minister may be opposing the judgment, or maybe those who support the opposition may be supporting the judgment. So I believe the public opinion these are all matters of policy, and public opinion certainly is divided. So I'm nobody to say I'm no expert. I do not know whether this is a good idea or bad idea. All I can say is that is the will of the people. That is the order of the people. In a democracy, what Parliament decides, what Parliament enacts, that is binding on all. And the problem here is what the Parliament decided, right or wrong, assuming to be wrong. Then if the Parliament is decided something wrong, there is a mechanism for correction of it. That is what democratic process is for correcting the same. The entire law can be completely repealed, amended, whatever way it likes, provided there is a public opinion demanding that. But the court cannot be used as a mechanism for undoing what the Parliament has decided on a matter of governance or matter of policy. See, we must respect the Parliament. We respect the court. A court finds an innocent man guilty of murders, sentence him to capital punishment. He is hanged. We respect the judicial verdict, not because the court is right. Even when the court has gone wrong, a judicial decision is treated as sacrosanct. And in the same way, a decision of the Parliament should be respected. And the courts, certainly a law enacted by the Parliament, if it is unconstitutional, can certainly be challenged before a court, and the court has got every power to undo it. So for example, where legislation is ultra vires. So today the Parliament enacts a law concerning, say, cooperative society is a state subject, or agriculture a state subject. Then that is something beyond the legislative competence of the Parliament, and therefore it is ultra vires. If a state legislature pass a law concerning external affairs, foreign policy, that is ultra vires the legislative powers of the state legislature. Therefore, such a law, the court has got every power to declare it as unconstitutional. On the contrary, these are areas Parliament is empowered to enact law, and it has to be, the will of the Parliament has to be, right or wrong, the Parliament's authority has to be respected, and it is a duty of the court to respect the authority of the Parliament. Now look here, this is an area, as I said, to repeat again, there's a public opinion is completely divided. There are thousands, lakhs and lakhs of people who oppose the law and welcome the Supreme Court judgment, and vice versa. Now the problem here is when the court has decided the issue, it has heard only a few people, and it has rendered the judgment entirely behind the back of the people. If in the matters of policy, like the electoral bond issue, if it is justiciable, then the first issue to be decided is who are all entitled to be heard. Can in a democracy we accept a proposition that the court can hear a elect few, I'm sorry to name Prashant Bhushan, Kapil Sibal and a few, and decide a matter? That would be most undemocratic.
So what you say seems to be very valid and true. Then why didn't the Attorney General and Solicitor General raise these issues?
No, that surprised me. It is not the first time it has happened. All these matters comes when matters of governance, matters of legislative policy is questioned before the court. The Attorney General and the Solicitor General, who are supposed to defend the government, the parliament, they instead of standing up and saying that, look here, this is the will of the parliament. These issues are not justiciable. Who can come to a court? If Prashant Bhushan can come, Kapil Sibal can come, provided their rights are infringed, and they can invoke Article 32 only if their fundamental rights are infringed. In the electoral bond case, in what way fundamental rights are infringed? If the fundamental rights, see, you can come to a court even when you complain a violation of fundamental rights, that right should be specific to you. If it is you say a fundamental right is infringed, in no way, in any manner specific to you, like 140 crore people of this country, then that issue is not justiciable. So this has happened ever so many times. When Article 370 issue came, then nobody ever raised the issue that it is not justiciable. Then the NJSC case came, when the legislative policy to create a commission for the selection appointment of the judges of the High Court and Supreme Court. Then it was challenged in the Supreme Court. The Attorney General did not, despite being repeatedly being told, Mr. Erred, he did not raise his voice. He did not say these petitions are not maintainable. And it is quite surprising. So if the courts are, and ultimately why probably, I don't want to cast any attributes or aspersions on them, but I can't help saying that certain lawyers want these issues of policy or governance to be agitated before the court, so that 5 judges, 7 judges, 9 judges are constituted, and it gives them a lot of prominence to them. Because, see, literally, these lawyers, they, in a sense, substitute the parliament even. So I am afraid to say there is something more than what I could see in the authority, the Attorney General and others concerned even failed to raise the issues of the very maintainability which even a junior lawyer would have raised. Thank you.